So now let's take a look at partnerships with Unit 1. So what is a partnership? Well, a partnership is the coming together of two or more persons who conclude a partnership contract or agreement with the aim of running a business for the purposes of making a profit for their joint benefit. So all partners should contribute money, property, services or labor, skills or experience that will be at the disposal of the partnership for the purposes of running the business, and all these are subjected to risk. So what are the characteristics of a partnership? Well, it's formed by a contract or agreement. It has an aim of making a profit. It needs to have an association of at least two people or more. It is not a juristic person. And the exception where it is a juristic person is during litigation and insolvency. And lastly, partners are jointly and severally liable for the partnership's assets and liabilities, so there's risk. And you should know that a partnership contract should have all the essentialia, which are the characteristics that set it apart from other contracts. So the essentialia of the partnership contract is that each partner must contribute something of value. The business should be carried out for the joint benefit of partners, and the purpose is to make a profit. And then the partnership contract should be legitimate. So if all these four essentialia are present, then there's proof of partnership. But they should still have an intention to conclude a partnership. So even with these essentialia, there still needs to be intention. So what are the general requirements of a partnership contract? Well, parties must reach consensus. Parties must have contractual capacity. The contract and performance must be legal. Performance must be physically possible. And contractual formalities, if any, must be complied with. So what are some of the rights of partners in a partnership? Well, they have the right to profit, remuneration, interests, and indemnity. They have the right to control and related matters. So control, so the power to take part in management. Access to books, access to partnership's assets, to promote or boost the partnership's business. And then no partner can deny other partners access to the assets of the partnership. And no partner can take or dispose for personal use the partnership's assets without the consent of other partners. So what are some of the duties of partners? So each partner undertakes or commits to do the following: contribute something of value, share in the losses, exercise care, and maintain bona fide or good faith to act honestly at all times. Now let's take a look at litigation between partners. So we have actio pro socio. So this is where you compel a partner to make their contribution as per the partnership agreement. And then you could also interdict a partner from misusing the partnership assets. And then we have the actio communi dividendo. So this is used by partners to dissolve an asset that's jointly owned in undivided shares after dissolution. Now let's take a look at the authority of each partner to bind the partnership to third parties. So first we have a mutual mandate. This is where the transaction is within the scope of the partnership. So natural, operation by law. And then we have estipel. This is where partners created a false impression that the partner has authority to bind them. And then in that breath we have express authority. So these are instances where the transaction is beyond the scope of the partnership. So this is express authority. And then we have ratification. So this is when the contract or transaction is accepted by partners after the fact, where the transaction is beneficial to the partnership. Now let's take a look at delictual and criminal cases with partnerships. So a partnership is not a legal person, thus it can't commit a crime. However, all partners can be guilty of an offense committed by one of the partners when promoting the interests or business of the partnership, unless they prove that they didn't partake in the crime, that they couldn't prevent the crime, or that they weren't members of the management committee that committed the offense. Now let's talk about the liability of partners to third parties. Well, partners are joint creditors and debtors of third parties. Third parties can institute actions against the partnership, but not individual partners. And partners can agree with third parties that they're jointly and severally liable for debts, or that one partner's liability is limited. But partners remain jointly and severally liable to partnership creditors when the partnership is dissolved, but remain co-creditors for debts owed to the partnership. Now let's talk more about litigation. So in litigation such as actio pro socio, parties can't institute actions in the name of the partnership. However, where partners sue or are being sued by third parties, then the name of the firm or the partnership can be used. And the plaintiff isn't required to name partners. If they do, then an error or omission is not a defense. Execution of judgment will first be against the assets of the partnership, and when they're finished, the assets of individual partners will then be used to satisfy the judgment of the court. And finally, let's take a look at the various grounds for dissolution of a partnership, so the termination of a partnership. So it can happen through agreement between partners, a lapse or expiry of time or completion of business, change in the membership of the partnership, death, retirement notice, retirement and admission of a new partner, by an order of the court if the court deems it just and equitable, by breach of essential term of partnership agreement, irreparable breach of trust, no prospect of profit, personal circumstances, and sequestration of the partnership's or private partner's estate. Now let's start with an introduction to company law. So what is a company? So a company is a juristic person that's incorporated or founded in terms of the Companies Act or the previous act and the closed corporations that have been converted into companies. So it's a juristic person that's incorporated or founded in terms of the Companies Act. So a company is a group of entrepreneurs who come together to form a business vehicle in the form of a company. And they do this with the aim of making a profit or sometimes for the common good or betterment of an aspect of society. So these non-profit companies. So let's take a look at some of the characteristics. So once a person or group of entrepreneurs have complied with the requirements of registering a company, the company is incorporated, so it comes into existence. So the Companies and Intellectual Property Commission, the CIPC, issues an incorporation certificate and registration number. So once the company is registered and the certificate is issued, it acquires separate legal or juristic personality. Therefore, it exists separately or is distinct from its founders or incorporators or shareholders. So a company isn't a natural person, and therefore it needs organs or directors to represent it, and these are viewed as separate legal persons. So what are the implications of separate legal personality? Well, the company bears rights and duties, the assets of the company are owned by the company, and a company can sue or be sued in its own name. A company is liable for its own debts, and shareholders enjoy limited liability. So companies exist independently from their shareholders, and companies exist perpetually or indefinitely, regardless of changes in the shareholding, unlike partnerships. The company is entitled and bound by the Bill of Rights in the Constitution, and shareholders in their capacity don't have the right to represent companies, unlike partners and partnerships, and companies need organs to represent them. So these are natural persons known as directors. So companies can be formed by one person. NPCs can even exist without members but must be founded by 3 persons. So non-profit companies can exist without members but they need to be founded by 3 people. And companies can be formed for non-profit purposes, unlike partnerships. And companies are formed through incorporation. So there is a formal process and requirements prescribed by the Companies Act, unlike an agreement and without formal requirements like partnerships. But now let's talk about piercing or lifting the corporate veil. So this is essentially disregarding the separate legal personality of a company. So in some exceptional cases, legislation and courts may disregard the separate legal personality of a company. This is in order to find the real intention of those who control the company. For example, using the company to commit crime or evade taxes, etc. The court might say, okay, we're going to lift the corporate veil. So disregard the legal personality of the company. So what are the different types of companies? Well, we have profit companies, and their aim is to make a profit. So it has 4 subtypes. Then we have non-profit companies. They exist for a public benefit, not for profit. So let's take a look at the for-profit companies. So we have state-owned companies or SOCs, and the name ends with SOC. So companies owned by the state or government, for example, ESCOM. Then we have private companies. These end with PTY Ltd. And then we have public companies. These end with Ltd. And then we have personal liability companies. These end with Inc. And now let's take a look at the non-profit companies. So their name must end with NPC. And these are companies incorporated for public benefit, for example, cultural advancement, group interests, or fighting social ills. And the assets of the company must be used to advance the objective of the company. And assets aren't distributable to stakeholders. And then reasonable remuneration may be paid from assets of the company for work done or services performed for the company. And then it may not have shareholders or members. And then upon dissolution of the company, the assets should be transferred to a similar company or entity pursuing a similar cause. And then it must have 3 directors. Now let's talk about the pre-incorporation contract. So in common law, it's impossible to represent a company that doesn't exist. So there's no principal, no agency. However, it may be necessary to conclude contracts on behalf of entities that aren't yet incorporated or established to avoid losing a lucrative deal. So that's where we might have a pre-incorporation contract to represent the company even if it's not established or incorporated yet. So under the pre-incorporation contract, you have the stipulation contract, a cession of rights under option, acting in one's own name and delegation to the company when it's incorporated, and then nomination, where you enter into an individual contract with one person and they have the right to nominate a third party, which is the company once it's incorporated. Now let's take a look at the incorporation procedure, so how a company comes into existence. So a company is incorporated by creation or completion and signing of an MOI. So the MOI is the governing document of a company. So a company is incorporated by creation or completion and signing of an MOI by one or more of the shareholders in a private or personal liability or public company and 3 people in an NPC or SOC. So it's incorporated when the people create and sign the MOI, and then this is by one or more shareholders in a company, and then by 3 people in a non-profit company or a state-owned company. So the completion and filing of the Notice of Incorporation, NOI, and this notifies the CIPC that they are filing this as a company. And then payment of the prescribed fee. So you sign the MOI, you complete and file the Notice of Incorporation, and you pay the prescribed fee, and then the company comes into existence. So once all these are submitted at the CIPC and all requirements are complied with, the CIPC will register the company, assign a registration number, and issue a certificate of registration. So the company comes into being from the date of registration and becomes a separate legal person. So the Companies Act facilitates the participation of individuals in the socio-economic well-being of the country. So it boosts transparency, job creation, innovation, efficient regulation, promotes the interests of stakeholders. And then Section 72 provides for the establishment of a social and ethics committee in companies. This is for CSR and Ubuntu. Now let's talk about the Memorandum of Incorporation with Unit 2. So the Memorandum of Incorporation, or the MOI, is the governing document in the company, and it regulates relations within a specific company. It's used as the incorporation or establishing document of the company. But the MOI must be consistent with the Companies Act. If not, then it's void to the extent of the inconsistency. Let's talk a bit about the rules of the board and shareholders' agreements. So directors may create rules, and then shareholders may create shareholders' agreements, and they should also be consistent with the Act. Let's talk a bit about doctrine of constructive notice. So this has been partly abolished in the current Companies Act, but in the past, third parties concluding contracts with the company were required to know that the company has the capacity and the company's representative has the authority to conclude contracts. So third parties had to know the contents of the company documents, MOIs, etc. So some companies' MOIs contain special restrictive conditions on the capacity and authority of those who are representing companies and requirements of amendment and prohibition of the amendment. So essentially restricting the authority of directors for certain transactions. So the Notice of Incorporation, NOI, and the Notice of Amendment, NOA, should inform third parties about such provisions. And in such a case, the company name must end with RF, and this means that there are special restrictive conditions, and compliance with the provision is required when concluding contracts. But now let's talk a bit about constructive notice in personal liability companies. So in Inc. companies or personal liability companies, third parties are also deemed to know that current and past directors are jointly and severally liable together with the company for debts that were contracted during their terms of office. So this is how doctrine of constructive notice is still partially applicable. So you should know that the MOI and the rules of the board are binding between the company and each shareholder, between the shareholders themselves, between the company and each director, between the company and prescribed officers, and between the company and any member of the board or audit committee. But the MOI and rules should be consistent with the Act, otherwise they're void to the extent of their inconsistency. And let's talk a bit about shareholders' agreements. So these should also be consistent with the MOI and the Act. So shareholders may also agree on certain matters, and such agreements will regulate relations between them and the company. So there are alterable and unalterable things that you can change in the MOI. So alterable things are things that you can change in the MOI. So Section 44 of the Act provides the board with the authority to authorize financial assistance for the purchase of the company's shares, except to the extent that the MOI provides otherwise. And then there are some unalterable things that can't be changed in the MOI. So Section 76 of the Act provides that directors of the company, when representing the company, must exercise their powers and perform their functions in good faith and for proper purpose, in the best interest of the company, and with a degree of care, skill, and diligence expected of them. So unalterable provisions can only be changed in the MOI if the change provides a more rigorous or stricter provision. So the MOI is the constitutive document of the company and is required when registering the company. And it regulates the rights, duties, and responsibilities of shareholders, directors, and others in the company. But what happens with amendment of the MOI? Well, amendment of the MOI requires a rigorous process to amend it, since it's an important governing document. So the board or shareholders holding an aggregate of 10% or more of the shares or voting rights can propose an amendment. And then it can also be done by court order, so no special resolution is required here. But in general, amendment of the MOI will usually require a special resolution, so 75% plus of the voting rights. And then the NOA, or the Notice of Amendment, must be filed at the CIPC and the fee should be paid. And the date the amendment will be made is the later date between acceptance of filing of the amendment by the CIPC or the date specified in the NOA, the Notice of Amendment. But now let's talk about companies' capacity. So what a company can do in the sphere of business, for example, concluding transactions, etc. Let's talk about the ultra vires doctrine. So the ultra vires doctrine is where companies had the capacity to only conclude contracts that were provided for in their objects or objectives clause in the past, right? This happened in the past. So transactions that were outside of the scope of the company were void. So this was unfair to third parties who contracted with the company. So Section 19 and 20 of the current Act solve this injustice caused by the ultra vires doctrine. So Section 19 provides that a company has all the legal powers and capacity of a natural person except to the extent that the company can't exercise such powers or can't have such capacity, or the MOI provides otherwise. For example, the companies can't get married or whatever. And then Section 20 provides that in instances where the MOI of the company prohibits, limits, or restricts any actions by the company, or directors don't have the capacity to represent the company, and this is because of the prohibitions, limits, or restrictions in the MOI, those actions are still valid between the company and third parties. Therefore, even if the MOI prohibits a transaction, or the director lacks the authority because of the MOI prohibiting them, the contract is still valid with the third parties. Such contracts are only invalid between the company and shareholders, directors, and prescribed officers. Therefore, the company can hold the director who acted in contrary to the MOI personally liable for damages. This is because there was a breach of fiduciary duty going against what's in the MOI. So we also have ratification. So Section 20 allows for a general meeting to ratify or accept the contract that was contrary to the MOI, or maybe a contract where someone didn't have the authority to conclude it. So you can ratify or accept the contract that was contrary to the MOI with a special resolution. And then we have restraint or interdict. So Section 20 allows organs and other stakeholders such as unions to apply to court to restrain a transaction that's contrary to the Act. So interdict is basically prohibition from concluding any provision that contravenes the MOI. So Section 20 provides that organs, so shareholders, directors, may apply to the High Court to restrain the company or directors from concluding any transaction that contravenes the MOI. So this doesn't affect the damages of the third party, provided they acted in good faith and had no knowledge that the MOI restricts this transaction. And then we also have claim for damages by each shareholder. So this provides that each shareholder has a claim against any person who intentionally, fraudulently, or with gross negligence causes the company to contravene the act and the MOI unless the transaction is ratified. Now let's talk about company representation. So the board of the company or the board of directors of the company has the power to control and bind the company. Companies can also be bound by agents of the company who are granted actual authority, so express or implied authority. Agents can also bind the company based on ostensible authority. So ostensible authority is where the company created an impression that the agent has the authority, whereas this isn't the case. So express authority is granted to an agent in the MOI or by a board resolution. Agents must accept delegation of powers, and implied authority is when an officer in the company performs the functions of the office. The board may appoint one director to represent the board in concluding contracts or appoint another officer. Let's take a look at an example of ostensible authority in Estapel. For example, let's say the MOI of a company says that John is the only director that has the authority to conclude contracts on behalf of the company. But then for the past 5 years, the company let Josh conclude contracts on behalf of the company. So essentially, another director concluded contracts for the company and they've honored the contracts despite Josh not having the authority. 1 year, the board refuses to pay a contract concluded by Josh with a third party, and they say Josh doesn't have the authority. But what the third party can do is that the third party can argue that the company gave Josh ostensible authority, thus Estapel is applicable. So they have to honor the contract since they gave the impression that Josh has the authority to conclude contracts with third parties. But let's take a look at the 4 requirements for ostensible authority. Well, the company must have intentionally or negligently misrepresented to the third party. And then the misrepresentation must be serious enough to reasonably mislead the third party. And then the third party must have been led to act because of the misrepresentation. And then the third party must have suffered damages due to acting based on misrepresentation. Now let's take a look at the Turquoise rule. So the Turquoise rule is in terms of the common law and statutory Turquoise rule. So the common law Turquoise rule provides that when a third party acting in good faith when concluding a contract with a company can assume internal requirements have been complied with in the company. Therefore, third parties don't have to spend resources trying to find out if internal requirements have been complied with or if someone has the necessary authority to conclude a contract. So the company will be bound even if the internal requirement wasn't met by the director, etc. However, the Turquoise rule won't be available when people pretend to be members of the board. So it's only available when third party contracted with the person who has general authority to bind the company, but the internal requirement wasn't met. So a member of the board or officer. Now we move on to capital with Unit 3. So capital is investment of assets by founding shareholders, or the issuing or selling of shares to existing and new shareholders, so share capital. It could also be profits made from services or products offered by the company, or reserves or savings in the company's bank account, or loans or debentures. So what is share capital? Well, share capital is the authorized share capital and issued share capital. So the MOI will provide different classes of shares, numbers of shares, and the rights and limitations of those shares. And then what is authorized share capital? Well, this is the classes of shares and the number of shares that the company is authorized or allowed to issue or sell in order to raise capital or money. So this is the money the company can raise. And then issued share capital is the money the company has collected or made through the sale or issue of shares so far. So what is a share? Well, a share is a personal right that represents a proprietary interest in the company. So it entitles the holder the following rights: dividends when declared, net assets when the company is wound up or dissolved, right to information, and the right to vote. Now let's take a look at the different classes of shares. We have ordinary shares and preference shares. So ordinary shares is where you can vote, dividends are not fixed, or they're fixed and they have rights to net assets upon winding up. And then preference shares is where the holder is usually preferred in terms of dividends and it's usually a fixed 20%. What about participating preference shares? Well, this is where shareholders can share in the residual profit after receiving preference. But then what about redeemable preference shares? Well, this is where shares can be repurchased or redeemed by the company. And then what are term or period shares? Well, these are shares issued for a specific term or subject to a condition. If the term expires or the condition is fulfilled, the shares can be repurchased by the company or converted to another class of shares. But then what about cumulative preference shares? Well, this is where shareholders will enjoy missed dividends if provided in the MOI. But now let's talk about variation of class rights. Well, the rights of shares in the MOI can only be amended by a special resolution, so 75% plus of votes in favor of that amendment. That said, shareholders have the right to use the dissenting shareholders' appraisal right. And this is if the amendment materially changes the rights of shareholders. So it materially or negatively changes the rights of the shareholders. For example, it limits their rights, right? And this basically encourages the company to buy their shares. But they must notify the company that they intend to oppose the proposed resolution, and they must actually vote against the resolution or oppose the resolution in the meeting. So now let's talk about how companies raise capital. Well, companies can access loans from banks or individuals. They can render or provide a product or service, issue shares, JSE or non-JSE listed. But then private companies can't issue shares to the public. Public companies can though. Shares of public companies which aren't listed on the JSE must be issued together with a prospectus. What is a prospectus? Well, it contains comprehensive information about the finances and adequately informs potential investors to make informed decisions on whether or not to invest in the company. Listed shares don't need a prospectus unless it's an IPO, an initial public offering. So now let's talk about the solvency and liquidity test. So this is to protect companies' finances or capital and protecting shareholders or stakeholders' interests and to develop the economy, right? So the solvency test is where the assets of the company, when fairly valued, must equal to or exceed the liabilities of the company. So assets need to be bigger than or equal to liabilities. And then the liquidity test is where the company must be able to pay its liabilities that fall due in the ordinary course of business in the next 12 months after the test is done. So they essentially need to be able to pay their debt due in the next 12 months. So if this isn't complied with, the company can't transfer or use its money or assets. So before any indirect or direct transfer of money to anyone, the company must comply with the solvency and liquidity test. For example, before they offer financial assistance to employees to purchase shares or distributions. Now let's take a look at distributions. So what is a distribution? Well, it's a payment of dividends to shareholders, or when a company repurchases its shares, or a company gets into debt for the benefit of shareholders, or a company forgives a debt owed to it by its shareholders or any other person in the company or group of companies. So that's what a distribution is. And then the company can only make a distribution if it's in terms of an existing obligation, for example, it owes dividends, or in terms of an order of court, or where the board of directors authorize such a distribution. And again, it must reasonably appear that the company will comply with the solvency and liquidity test before a distribution is made. So the board must take a resolution confirming it's applied the solvency and liquidity test and reasonably confirm that the company will comply with the test after distribution. Distribution must be effected within 120 days after the application of the solvency and liquidity test. And a director who's present at a meeting but fails to vote against the resolution where the company won't comply with the solvency and liquidity test will be held personally liable for damages to the company. Now let's talk about the repurchase of shares or the acquisition of shares of a company by a company. So this is regarded as a distribution as it's a transfer of the company's money to shareholders. It follows the same requirements as a distribution. That said, a subsidiary company can't acquire more than 10% of the shares of any class in its holding company. Such shares don't entitle subsidiary voting rights. And now let's talk about financial assistance. So the board may authorize financial assistance by way of loan, guarantee, or provision of security to any person for the purchase of the company's shares or related company. So, for example, assist employees or other stakeholders to purchase shares in the company. And this is if the MOI allows it. So the financial assistance doesn't include circumstances where the company's business is to provide financial assistance. The financial assistance must be in line with an employee share scheme or in terms of a special resolution adopted by shareholders within the previous 2 years. And the board must ensure and confirm that the company will comply with the solvency and liquidity test after the financial assistance is given. and the proposed financial assistance will be provided under terms that are fair and reasonable to the company. Now let's talk a bit about accounting practices. So companies are required to provide accounting records in one official language in their registered offices. Companies must prepare its annual financial statement within 6 months after the end of the financial year. In public companies, annual financial statements must be audited, and it must include the director's report. Annual financial statements must be approved and signed by the authorized director before being presented to shareholders. Now let's talk a bit about the auditor. So public companies' financial statements must be audited. Annual financial statements of certain private companies and NPCs must also be audited. For example, if it's in the public interest to do so, given the company's significance, then maybe it'll be audited, regardless of whether or not it's a public company. So the auditor must be appointed upon the registration of the company and each year at the AGM, Annual General Meeting. And then the auditor must be registered in terms of the relevant legislation. The auditor must be acceptable to the audit committee, and the auditor must be independent from the company. So the aim is to ensure that the books of the companies are examined to determine whether they represent the actual financial state of the company. Now we move on to shareholders, organs, and officers with Unit 4. So organs of companies are the natural persons who represent and control the company. So directors are natural persons who represent and control the company in the commercial world. And then shareholders are natural persons who incorporate or start the companies and invest in the companies. So juristic persons can also be shareholders. So what is a shareholder? Well, this is a person who holds a share or shares issued by a company and is registered in the company's certificated or uncertificated shares register. But a person ceases to be a shareholder in death, insolvency, dissolution of the company, or transfer and sale of the shareholder's shares to another company, quasi-lien. So what are certificated shares? Well, these are shares evidenced by a share certificate. So a share certificate will provide the name of the company, the name of the shareholder, number and class of shares held, and restriction on the transfer of those shares. And then uncertificated shares are shares that aren't evidenced by a certificate. So record of uncertificated shares is also administered and maintained by the Central Securities Depository, so CSD. Now let's talk about transferring securities or shares. Well, a share is a personal right, so it's transferred by cession. So ceding of a personal right by a cedent to a cessionary. So when you transfer the share, they have the right to share in the dividends when they're declared. They have a right to participate in meetings and votes. They have a right to share in the net asset value upon winding up of the company. And then registration of shares is not a requirement for the transfer of shares. Now let's talk about statutory remedies for unlawful conduct by majority shareholders. So this essentially restrains the company from transgressing the act. So each shareholder has a claim against anyone who intentionally, fraudulently, or due to gross negligence causes the company to transgress the act or the MOI. Any person who transgresses the act is liable to a person who suffers loss or damage due to the transgression. And then we also have a declaratory order, and this is available to shareholders. So the court can declare, protect, rectify harm done by the company or directors in contravention of the act, MOI, rules, or violation of any right. And then another remedy is relief from oppressive or unfairly prejudicial conduct or unfairly disregards the interest of the applicant, section 163. And then another statutory remedy we have is dissenting shareholders' appraisal rights, section 164. So a shareholder may serve a written demand that the company pay a fair value for the shares of the shareholders. If the shareholder opposes the resolution that materially and adversely affects their shares. Then we also have statutory derivative action. So a shareholder, director, prescribed officer, trade union, or any other representative of employees or any person granted leave by court, so locus standi, may serve a demand on a company to commence or continue legal proceedings or related steps to protect the legal interests of the company. So let's take a look at the organs and officers of a company. So we have directors and shareholders. Then we have social and ethics committee, and this ensures that the companies are responsible citizens. So they contribute to the betterment of the community, and they should also conduct their affairs ethically. Then we also have an audit committee. So members ensure proper appointment of an auditor, and the auditor executes their duties properly. So we've got directors and shareholders, social and ethics committee, and an audit committee, which are the organs and officers of a company. Now let's talk about shareholders' meetings and resolutions. So shareholders have their say in meetings. We have general meetings, GMs, and annual general meetings, AGMs. In public companies, AGMs are held within 18 months of the incorporation of the company, and subsequent AGMs should be held once every calendar year, but not more than 15 months after the previous AGM. And decisions taken at shareholders' meetings are known as resolutions. And there are two types of resolutions. So ordinary resolutions, where you need 51% or more of the voting rights, and then special resolutions, where you need 75% or more of the voting rights. Now let's talk about directors and standards of their conduct. So directors' common law and statutory duties are standards that should be complied with by directors when representing the companies. So the statutory duty and the common law duty are almost the same. You can invoke any of them. So we have directors' common law fiduciary duty to act in good faith and in the best interest of the company. So good faith being honestly, right? Then we have directors' common law duty of care and skill. So it depends on the size and nature of the company, and you need to apply the skill and experience, and obviously you're not held liable for little errors in judgment. And then we have the statutory duty to act in good faith, in the best interest of the company, and for proper purpose, and duty of care and skill and diligence. And then the business judgment rule is basically a safe harbor for directors in case they get accused of not acting in good faith or not applying their care, skill, and diligence. So directors are entrusted or hold assets for the company. Therefore, they're in a relationship of trust with the company. So the common law fiduciary duty of good faith requires directors to avoid a conflict of interest, exercise powers for purposes they are granted, act with uninfluenced discretion, and not exceed the limits of their powers. And then we look at the statutory duty to act in good faith for proper purpose and in the best interest of the company. So you must act honestly in good faith, right? Exercise their power for the intended purposes, proper purpose, and always promote the interests of the company. And we also have the statutory duty of care, skill, and diligence. So directors, when executing their duties, must act with the duty of care, skill, and diligence that's reasonably expected of a person carrying out the same functions as those that are carried by the director of that company, and having the general knowledge, skill, and experience of that director. So duty provides the reasonable director's test. So it has objective elements. Having knowledge, skill, and experience of that director has subjective elements. But now let's take a look at the 4 elements of the business judgment rule, BJR, where directors can escape liability for the breach of duty of care, skill, and diligence, and duty to act in the best interest of the company. So this is where directors can escape that liability for a breach of duty. So directors can escape liability if the director took reasonably diligent steps to become informed about the matter, the director had no financial interest in the decision, so they or their relatives did not stand to gain or profit. Also, if the director had a personal interest, they disclosed it, or if the director believed on a rational basis that the decision was in the best interest of the company. So if all these are present, then the director escapes liability. So directors have the duty to disclose personal financial interest, and then directors shouldn't run the company recklessly with gross negligence. So let's take a look at the liability for breach of statutory duties. So a director will be liable for the breach of statutory duty of good faith in line with common law breach of the duty to act in good faith. And then liability for breach of statutory duty of care, skill, and diligence, or failure to comply with the provisions of the Act or MOI will be based on delict in line with the common law. Now let's move on to the winding up, business rescue, and deregistration of companies with Unit 5. Let's talk a bit about the role of winding up a company. So, to wind up a company is the process of dissolving a company, and the role of winding up is to collect all the assets of the company, convert them to cash, and pay creditors of the company what's due to them as per their order of preference, and use the residue to distribute to shareholders. So for solvent companies, we use the Companies Act 71, and for insolvent companies, we use the Companies Act 61 and the Insolvency Act 24. So now let's take a look at the winding up of solvent companies first. So here we have voluntary winding up and then winding up in terms of an order of the court. So let's take a look at the voluntary winding up in terms of shareholders' resolution by the company. So voluntary winding up of solvent companies is initiated by shareholders with a special resolution. And it's a special resolution since it's a major decision. And the special resolution requires 75% or more voting rights. And this process is simpler and faster and creditors don't suffer any loss as the company is solvent. So the special resolution should be filed at the CIPC with notice and a prescribed fee. Prior to filing it, the company should furnish security to the master for company's debts within a maximum of 12 months after commencement of the process, or obtain consent from the master to dispense with security. And a liquidator will have the powers that are the same as those of a liquidator. Now let's talk about the winding up of solvent companies in terms of an order of the court. So this is done by the company. So it's by special resolution, or they apply to court to have its voluntary winding up to be continued by the court. And then this could also be done by the business rescue practitioner. So they apply to court because there's no reasonable prospect of success in saving the financially distressed company. And then you should know that the winding up of a solvent company can never be done by creditors. This is because they're not affected. The company doesn't owe them money or anything. So the company, shareholders, directors may apply to court on the grounds that directors are deadlocked and shareholders are unable to solve the deadlock, and as a result there's irreparable harm to the company, or business can't be conducted to the benefit of shareholders. And then the company, shareholders, or directors may also apply to the court on the grounds that shareholders are deadlocked in voting power and for a period of 2 AGMs have failed to elect directors to replace those whose terms have expired. So a shareholder with leave of court can also apply on the grounds that directors or prescribed officers or those in control are acting fraudulently or illegally, or assets are being mismanaged or wasted. And then the CIPC or the panel may apply to court on the grounds that those in control are acting fraudulently, illegally, and the CIPC or panel has issued a compliance notice and the company has failed to comply. And within the previous 5 years, enforcement procedures in terms of the Act or CC's Act were taken against the company and those in control for essentially the same conduct, resulting in a fine or conviction. Now let's talk about the winding up of insolvent companies. So this can be done voluntarily by creditors or by an order of the court. Now let's take a look at the voluntary winding up of insolvent companies by creditors. So this is voluntary winding up of insolvent companies initiated by shareholders' special resolution, known as creditors' voluntary winding up. So it's the shareholders' special resolution that is known as the creditors' voluntary winding up. So the resolution has to be registered, and the directors have voting powers in the election of the liquidator and are subjected to less prosecution than an order of the court. And then we have winding up of insolvent companies by an order of the court. So application can be brought by the company, creditors of the company, shareholders, or business rescue practitioners, etc. So the control of the company will be taken from the directors and vest in the master, the provisional liquidator, and the final liquidator. So the liquidator is supervised by the master of the High Court. So let's take a look at the different grounds of application. So it's by special resolution. If the company starts to run business before the certificate to commence business is issued or granted, if the company has failed to start business within a year after incorporation or suspended its business for a year, if the number of shareholders of a public company is fewer than 7, if 75% of the share capital of the company has become useless or is lost, if the company is unable to pay its debts, if the foreign company was dissolved in the country it was incorporated, or when it appears to the court that it's just and equitable for the company to be dissolved. So these are all the grounds of application of having an insolvent company wound up. Now let's move on to business rescue. So the aim of business rescue is to rehabilitate financially distressed companies to restore them to financial viability for the purposes of developing the economy and to safeguard employment for people. So it does this by doing 3 things. The first thing is granting companies a moratorium or grace period from the claims of creditors, right? The second thing they do is put the company under temporary supervision. And the last thing they do is develop and implement a rescue plan to rehabilitate the company. Or, if that's not possible, allow creditors and shareholders to receive a better return upon liquidation of the company. So the company can be placed under business rescue by a board resolution or by an order of the court when there's a reasonable prospect for saving the company. It can also be placed by creditors, shareholders, and employees that are affected persons and can apply for an order of the court to place the company on business rescue. Creditors of the company have to consider merits of the business rescue plan, amend it if necessary, and vote for its implementation. And then the business rescue practitioner develops the plan to save the company. And employees of the company that's under the business rescue plan are affected by the Labor Relations Act. And then deregistration is the process of removing a company or business entity from an official registry, the CIPC. Now let's move on to the introduction to closed corporations and membership interests with Unit 1. So the old Companies Act was complex. It wasn't easy to start a small company, and thus closed corporations were introduced. So we have the Corporations Act 69, and closed corporations were a simpler entity similar to companies. However, it's no longer possible to start a new closed corporation. The Companies Act 71 of 2008 provides a solution. So what are the characteristics of closed corporations? Well, they have separate legal personality, their legal capacity is unlimited, it's easy and less costly to form closed corporations, and they're subjected to simple legal formalities. And in a closed corporation, you can have a maximum of 10 members who are natural persons, and juristic persons can't be members in the CC. And then the solvency and liquidity test is applied, for example, in distribution of profits, etc. So to protect third parties who may conclude contracts with the CC, members of the CC may be held personally liable for failing to comply with the prescribed requirements when concluding contracts with third parties. And then the CC structure is flexible to satisfy specific needs of members in the CC. And then common law rules regulate the relationship between the CC, members, and third parties. And then CCs are required to provide accounting records. They don't have to be audited though. They just need an accounting officer, and this can be a member too. So closed corporations can continue to exist indefinitely until they're converted to companies. So now let's talk about the conversion of CCs or closed corporations to companies. So the CC files the notice of conversion from CC to a company to the CIPC, and then the prescribed fee should be paid. Notice of conversion must also contain the written consent signed by members holding an aggregate of 75% of members' interest. Then it should also be approved by members holding 75% plus of members' interest. And then the notice of conversion must also be accompanied by the MOI of the company. So once they do this, the CIPC will cancel the registration of the CC and give notice of conversion in the Government Gazette. Every member of the CC will become the shareholder of the company, and the shares that each member will hold don't need to be equal to the member's interest that was held in the CC. So the assets, liabilities, and obligations of the CC will now be held by the new company. And any legal proceedings or debts that are pending against the CC will be instituted or claimed against the new company. Now let's talk about the membership of a CC and members' interest. So CCs can only have a maximum of 10 members, and they're natural persons. The total aggregate of members' interest should always be 100%. Members' interest represents the single interest held by a member, and it's represented as a percentage. When one member's interest is partially or totally disposed, the member's interest should be readjusted to 100%. And then the CC may buy a member's interest but must add it to other members' interests. And two or more persons can't be joint holders of the same member's interest in the CC. But now let's talk about the requirements for a natural person to qualify as a member of a CC or closed corporation. Well, a natural person is entitled to a member's interest, example from a deceased estate. Or maybe they're a trustee of a testamentary trust, and no juristic person is a beneficiary of such a trust, so maybe through a will. And then a juristic person can be a member in their official capacity as a trustee, administrator, or executor for insolvent, deceased, mentally ill, or persons who can't manage their estate. This is the only instance where a juristic person can be a member. So how is a member's interest in a CC acquired? Well, the amended founding statement must be lodged, and then certificates signed by all members or on their behalf must be handed in. Now let's talk about the admission of an additional member into a CC. Well, a person can be added in the CC provided they contribute money or property in the CC, and the new member will be granted members' interest in terms of percentage. But remember, services are not regarded as contribution. Since members' interest of the CC must always be 100%, always during the existence of the CC, the new member's interest will have to be granted by adjusting the existing member's interests. Now let's talk about the acquisition of members' interest from an existing member. Well, they can acquire it through donation, purchase, or exchange. And then disposition of members' interest must be done in accordance with the association agreement, which is an internal document that regulates the relations within the CC. And then the association agreement will usually contain a preemptive right. And this grants the existing members the right to first purchase the members' interest before it can be made available to outsiders. And if there's no preemptive right in the association agreement, all members of the CC must consent to the transfer of the members' interest to outsiders. Now let's talk about the acquisition from an insolvent estate. Well, the trustee of the insolvent estate must sell the insolvent member's interest to the CC, provided there are other members other than the insolvent member, or sell to the existing members pro rata, so in proportion to their members' interest. Or the trustee of the insolvent estate must sell the insolvent member's interest to an outsider who qualifies to be a member, subject to the preemptive right. And then the adjustment or acquisition process must also be complied with, and the amended founding statement must be lodged. Well, what about the acquisition of members' interest from a deceased estate? Well, here the executor must deal with the members' interest in accordance with the association agreement. If the association agreement doesn't prescribe any direction, the executor must do the following. So they should transfer the members' interest to the legatee or heir of the deceased, provided the members consent. And if the members don't consent, the executor will sell the interest to the CC or the existing members or to an outsider. Now let's talk about the transfer of members' interest. So membership of a member commences on the date of registration of the amended founding statement. And since members' interest is a personal right, it's transferred by cession, which is the transfer of rights of members' interest. And it's safe to provide the certificate as proof of transfer of members' interest, but the transferor is still liable for what they owe to the CC. But now let's talk about security by means of members' interest. So like a share in a company, members' interest can be used as security. And what is security? Well, this is any property provided by the debtor to the creditor as a guarantee that the debtor will fulfill their obligation to the creditor. So when the debtor fails to fulfill the obligation, they will forfeit the property to the creditor, and security protects the interest of the creditor. But let's also talk about personal rights as pledge. Well, the personal rights of the member can be used as security for the debt owed by the member, and if the debtor fails to pay, the member's interest can be sold to satisfy the debt owed to the creditor. And the member remains the owner of the member's interest, and the creditor acquires a real right to the member's interest. And the member's interest forms part of the insolvent member's estate in the event that the member becomes insolvent. Now let's talk about cession in securitatem debiti, or security cession. So this is where the debtor transfers their member's interest rights to the creditor, and the two agree that the creditor will cede back the member's interest upon payment of the money owed to the creditor. This cedent, who's the debtor, has the personal right against the creditor, who's the cessionary, to cede back the interest in terms of the pactum fiduciae. Now we move on to internal and external relations and maintenance of capital and liability of members with Unit 2. So let's talk about the internal relationships between members of a CC. Well, internal relations between members of the CC are regulated by the association agreement. And this is where the CC has two or more members. And it is not compulsory for members to create an association agreement. And in the association agreement, members can agree on matters that are provided for in the CC's Act and any other matter that may be regulated in accordance with the Act. And the association agreement must be in writing and signed by each member, and it must be consistent with the Act. But now let's take a look at the alterable and unalterable provisions. So some of the unalterable provisions is the disposal of the insolvent member's interest. Another thing they can't alter is members who are disqualified from taking part in the management of the CC. So this could be persons under legal disability, minor, unrehabilitated, insolvent, person removed from office of trust due to misconduct, etc. Another unalterable provision is the power of every member to convene a meeting by notice. Now let's take a look at the alterable provisions. Well, here all members of the CC are entitled to participate in the management of the CC. So some members may be part of management and some not. Then another alterable provision is that the CC shall indemnify or reimburse members for expenditure incurred in the running of the business of the CC or preservation of the business of the CC. Then another thing is payments to members because of their membership shall be subject to the agreement of the members and be paid in proportion to the members' interest. So those are all the things that they can change. But now let's talk about the management of a CC or a closed corporation. Well, parties have equal right to participate in the management of the CC. Certain members may be excluded. For example, they may decide that 2 of the 10 members are responsible for management. And then decisions are adopted by 51% or more of voting rights, right? That's a regular resolution. And then crucial decisions require written consent of a member or consent of members holding 75% plus of the member's interests. For example, change of the main business of the CC is a crucial decision, or the disposal of the whole undertaking or business or a greater part of the assets of the CC, or the acquisition or disposal of an immovable property by the CC. Now let's talk about members who are excluded from management of a CC. So persons without legal capacity are disqualified from taking part in the management of a CC. So the following persons aren't allowed to take part in the management of the CC unless the court grants permission: an unrehabilitated insolvent, any person removed from an office of trust due to misconduct, any person convicted for crimes involving dishonesty, such as theft, perjury, fraud, or forgery, and then any person convicted under the Prevention of Corruption Act, and then any person convicted for an offense involving dishonesty, any person convicted for an offense involving the formation and management of a company or CC and imprisoned for at least 6 months without the option of a fine, and then any person who is disqualified from being a director of the company in terms of an order of the court may not participate in the management of a CC. But now let's talk about the capacity of members to represent the CC in contracts with third parties. Well, every member of the CC has an equal power to represent the CC. Other members can be excluded in the association agreement. An exclusion is only relevant internally, not externally with the third party. Thus, all members are agents of the CC. And any contract concluded by a member with a third party, regardless of whether it's in line with the business of the CC or not, will bind the closed corporation unless the member has no authority and the third party knows or ought to have reasonably known that the member has no authority. So let's talk more about the relationship of members in the CC, vis-a-vis. So they have a duty to act in good faith, so to act honestly at all times, to exercise power in the best interest of the CC, not to exceed their power. Members' interests shouldn't be in conflict with the interests of the CC. Members shouldn't make a secret profit. Members shouldn't compete with the CC. A member that has a personal financial interest must notify, and failure to notify members means the contract is voidable at the option of the CC, and any interested person may apply to court for an order in relation to the financial interest, and the CC will claim loss or CC may ratify. And then another thing is that they have a duty of care and skill. Members of the CC, when managing the affairs of the CC, owe the duty to act with a degree of care and skill that's reasonably expected from a person of the member's skill and experience. And this is an objective test, which includes subjective elements. Now let's talk about the acquisition of a member's interest. So, finances can be used when all members provide consent, when the solvency and liquidity test is complied with after the payment for acquisition of the member's interest, and failure to do so means every member who was a member before the acquisition of the member's interest and the former member to whom money was paid will be liable for all the liabilities of the CC before the transaction. Now let's talk about financial assistance in respect of the acquisition of a member's interest. Well, CCs can provide financial assistance for the acquisition of a member's interest provided these requirements are complied with. First thing is consent from all members. Then you need compliance with the solvency and liquidity test after financial assistance. And then failure to do so means members and beneficiaries will be liable for all the debts of the CC before the financial assistance. Now let's talk about payments to members. So the CC may pay members by virtue of their membership, and this may happen many times in the financial year. And it needs to be approved by the support of members holding 51% or more of the member's interest. The CC must still be solvent and liquid after the test, and failure to do so means the member should pay back. If the CC is wound up, payments made within 2 years before the CC is wound should be repaid to the CC by the member, unless the member can prove that after the payments, the CC could still comply with the solvency and liquidity test. So circumstances in which the members of a CC incur personal liability for the debts of the CC is where all members should consent. Solvency and liquidity test must be complied with. Now let's talk about the abuse of a CC or closed corporation. So this is when the business of the closed corporation is carried recklessly, negligently, with intent to defraud or fraudulently, so for example, contracting with third parties knowing the CC is insolvent. And the master, liquidator, or creditor may apply to court to declare the person who willfully participated in the running of the CC as such to be personally liable for the debts of the CC. So courts can also disregard separate legal personality if there's abuse of legal personality. Now let's talk about accounting practices in a closed corporation. Well, a closed corporation must keep financial records. In the founding statement, the closed corporation must put the date on which its financial year will end, and all members of the CC must ensure the financial statement is out in one official language within 9 months. And every CC must appoint an accounting officer, and the officer must provide written consent to be appointed. And this must be lodged with the founding statement to the registrar or CIPC.